Thank you, Madam Chair. Chairman Simons, in his testimony, mentioned the recent FTC fine of $5.7 million against the video social networking app Musical.ly. It's now known as TikTok, to settle allegations that the company illegally collected information on children in violation of the Children's Online Privacy Protection Act. You said this was the largest civil penalty obtained by the FTC in a children's privacy case, but in actuality, there really haven't been very many, and when you look at the circumstances here, I don't think the fine fits the crime. You had reports that they were collecting location data on children that was discernible to people in the neighborhood. They made it very difficult to close accounts. They made it practically impossible to complain. They would not delete profiles after someone did close an account. So, and by the way, do you all know the valuation of the Chinese company that owns TikTok? ByteDance. As of November 2018, ByteDance was valued at $75 billion. That means the FTC's record-setting fine was 0.0076% of ByteDance's value. No CEO is going to blink an eye at a fine that inconsequential. Companies will just see small FTC fines as the cost of doing business and will continue to elevate profits over privacy, especially when it comes to our kids. Commissioner Chopra and Commissioner Slaughter, you issued a joint statement in response to this. You said executives of big companies who call the shots at companies that break the law should be held accountable, I guess personally accountable. And the FTC has gone after executives when they have direct control and are calling the shots here. Commissioner Chopra, why was it important to make that statement? And is it clear the FTC has the authority to go after executives of tech companies for violating privacy laws?
Well, let me just say that the FTC goes after individuals all the time, especially when it comes to small-time scammers. I do think we need to level the playing field a bit and make sure that in our investigations when it comes to privacy, we are also looking at the role of individuals who made the decision that it was worth violating the law in order to profit. So I want to make sure that in our investigations, we are investigating that and we are holding them accountable when we have clear evidence of a violation. Because you are right, for some firms, fines are a parking ticket and a cost of doing business, and we cannot change behavior unless those penalties are painful, and often that means finding out who at the top called the shots.
Commissioner Slaughter, I want you to answer that, but I also heard you loud and clear on the privacy policies. Everyone knows that these notice and consent and privacy policies they're simply not working. It's particularly egregious when it comes to children and parents. In COPPA, they're completely inadequate to protect children's privacy. And I'm worried no matter how much that we revise those notice and choice provisions, it will not be sufficient, and companies will find ways around it to get to our children's data without parents fully understanding what their children are agreeing to share. The one answer was contained maybe in the FTC's 2012 privacy report that discussed reasonable collection limitations, which I understand to mean that companies only collect data that is consistent with the context of a particular transaction or the consumer's relationship with the business. It could also include limitations on sharing, sale, retention, and usage. Should Congress include a reasonable collection limitation section in privacy legislation going forward?
Thank you for the question, Congresswoman. Let me try to take both of those points quickly, mindful of your time. The first is, I agree with your point and with my colleague's point that fines can't be meaningless to companies. If we care about them, they need to be enough to effectively both deter specific wrongdoing by that company in the future and effectuate general deterrence. I would like to make a clarifying point because I've heard a couple of members talk about fines the FTC can levy. And just to be very clear, unlike some of our counterparts in Europe, we can't independently assess fines. Where we find a violation of an order or a rule, we can go to court and seek civil penalties, and a court could assess penalties. And then, in order to avoid that process, we can negotiate with a company to reach an outcome that we think is fair and just. But those are negotiated penalties. They're not levied fines, and I think that's a meaningful distinction. And secondly, the statement that my colleague and I released in the TikTok case did go to the question of individual accountability, making sure our investigations effectively assess where it lies if enforcement is proper. And I think we also have to think about the injunctive relief that we provide in any particular case. I think about it as a sort of a multi-legged stool. Again, how to best effectuate specific enforcement, making sure this company doesn't violate the law again, and general deterrence, making sure other companies know that if they don't follow the law, the consequences will be meaningful to them.
We're going to have to wrap. We're going to have to wrap it up there.
Okay. Then, short version of your question about purpose limitations. I agree. I think they're really important.
Thank you.
Thank you.